introducing some folks for our next panel, as well as getting folks ready for the anti-trans legislation panel. So I will be introducing Nikki Castro, who will be the moderator and introducing our panelists. And so we hope that you folks enjoy it. And if you have any questions or anything, please feel free to put your questions in the chat.
Hi, everyone. We are going to start with our anti-trans legislation and know your rights legal panel. I'd like to introduce one of our panelists. We have Stephen T. Hicklin, also going by Steve. Steve is a lawyer and LGBTQ plus activist. He was admitted to the California bar in 1988 and immediately began doing pro bono work for people living with HIV. In 2004, Steve joined the board of directors of the HIV and AIDS Legal Services Alliance Incorporated, which was at one time the nation's largest HIV-specific law firm, and held every executive position on the board. He also served 3-year terms on both the California State Bar's Interest on Lawyers Trust Accounts Commission and its Standing Committee of the Delivery of Legal Services, advancing access to justice statewide. In 2015, Steve and others founded the Transgender Legal Assistance Clinic, for which Steve is the supervising attorney. In partnership with the LGBTQ Center OC and UC Irvine School of Law, the clinic assists transgender persons with name change and gender marker change petitions for filing with the courts. Steve has his own practice in Orange County, prosecuting LGBTQ discrimination and mortgage-related cases. He has been with his amazing husband, Philip Hillenbrand, for the past 19 years. They live in Santa Ana. Our second speaker today is going to be Samuel Kishiyama. He is a second-year law student at the University of California, Irvine School of Law. Before law school, he worked as a paralegal for Free State Justice, a nonprofit organization that provides legal aid to LGBTQ+ Maryland residents. During the summer, he interned with the Equal Employment Opportunity Commission. He is currently a student leader for the Transgender Legal Assistant Clinic at the University of California, Irvine School of Law. Steve and Sam, feel free to turn on your cameras and unmute yourselves. Hi, it's nice to see you both.
Good afternoon, everyone. Happy Pride.
Happy Pride.
So I'm going to lead off today. Both Sam and I work on the Transgender Legal Assistance Clinic, and we're delighted to be here. First, my pronouns are he, him, his. And of course, the legalese needs to start. It'll be brief, I promise. This is not considered legal advice. If you have a legal issue, please reach out to an attorney to talk about it. And these are our views, but there may be others. So every case is different, every case is specific. All right, first, wanted to talk about the legal issues that are occurring across the country with regard to transgender rights. We have had some huge wins, and I think that that's going to be the most important takeaway from today's presentation on legal rights, is that things are getting much, much better for the transgender community. They are far from perfect. We have a lot of work to do, but things are getting much, much better, not just in California, but all around the country. So that's huge. One that I wanted to talk about was Dr. Rachel Levine being approved by the US Senate as the Deputy Secretary of Health and Human Services. Now, Dr. Levine, if you've ever heard her speak, she is amazing. She is smart, she's kind, she knows her stuff, and she doesn't get upset. She is just, she's amazing. She was the medical director for the state of Pennsylvania before being approved as the Deputy Secretary of HHS. She is the first transgender person approved for a position in the federal government by the Senate. So I think that's huge. I mean, that speaks to what trans people can do. We've always known that trans people are every bit as smart and hardworking and capable as everybody else. But now the Senate has recognized that, which I think is great. There's a new case that came down a couple of years ago called Bostock versus Clayton County. And that's a big, big case for the transgender and the larger LGBTQ community. That case held the Civil Rights Act of 1964, and in particular, Title VII, applies to the LGBTQ community. And the woman in this case was a woman named Amy Stevens. And Amy she's passed away. Amy was working in a funeral home before she transitioned. And she was doing a great job. She'd worked there 10 years. She got great performance reviews. Then she transitioned and she was fired by her boss because she presented as a woman. Well, the problem with that, according to the majority opinion in Bostock versus Clayton County, is that that is discriminating on the basis of gender. Amy Stevens was doing a great job before she transitioned. There was no reason to assume that she wouldn't do a great job after she transitioned. And so that was clearly discrimination on the basis of sex. Bostock versus Clayton County, the argument on behalf of Amy Stevens and the other plaintiffs in the case was directed at Neil Gorsuch. This was a 6-3 decision with Gorsuch writing the opinion. Gorsuch was appointed by Trump, and he's actually writing the opinion, affirming that LGBTQ people, including Amy Stevens, are protected by the Civil Rights Act of 1964 and Title VII, because otherwise it's discrimination, and it's discrimination on the basis of sex. So that argument has all sorts of ramifications for how LGBTQ people can bring cases based on discrimination using Title VII of the Civil Rights Act of 1964. Another case I wanted to talk about was the case of Gavin Grimm. And Gavin was a high school student, and he was presenting as male, but was using the men's restroom as he had every right to do. But and nobody in the school was having a problem with Gavin using the boys' locker room or the boys' restroom. But then some parents got a hold of the situation and decided that they were going to cause trouble, and they did. So Gavin was forced to use a bathroom that was in the nurse's office. It was a single-use restroom, but it was all the way across campus. It was stigmatizing. It was difficult for him to get there. So Gavin Grimm sued, and his right to use the locker room and the boys' restroom at his high school was upheld by the Sixth Circuit Court of Appeals. Great win. And finally, on a more widespread level, Pose actress MJ Rodriguez and Orange is the New Black actress Laverne Cox are breaking new ground. They've both been nominated, and Laverne Cox actually won an Emmy for their portrayals of characters in these shows. And what I love about that is that trans people are front and center, and they're being seen by everybody around the country as just like everybody else, which is exactly true. They're just trying to live their lives and do the best they can in this sometimes rough world. And they're breaking barriers, which I think is absolutely wonderful. Any questions about any of that? Seeing none. Certainly, I don't want to minimize the fact that the transgender community does face some real challenges. And 52% of transgender youth have seriously considered suicide in the past year, which is heartbreaking. Life expectancy for trans women of color is 35. Unemployment is 4 times that of the general population. And I don't want you to consider those statistics as tragic. They're not. They're getting better. All of those things are getting better. And that's the message I really want you to take away from today. But there are some problems on the horizon. and one of them is a case called Masterpiece Cake Shop. Now, the gentleman in Masterpiece Cake Shop, a guy named Jack Phillips, was a master baker, and two men wanted to get a cake for their wedding. And Jack Phillips refused to bake it. And so he actually ended up being fined by the Colorado Department of Human Rights for refusing a same-sex couple. And that went to the Supreme Court in a 7-2 decision, with only Ruth Bader Ginsburg, God rest her soul, and Sonia Sotomayor dissenting. The Supreme Court said that the Colorado Civil Rights Commission didn't sufficiently take into account Jack Phillips' argument that his religion prevented him from making a cake for a same-sex couple. Now, I find that argument tough to follow, but if you'd like to, you can read the opinion. Following on that case, Jack Phillips refused to bake a cake for a transgender woman, saying that it would be celebrating transgender rights, and when he was challenged by the Colorado Civil Rights Commission, he said he was being persecuted for his deeply held religious beliefs. Now, I think that that's really the crux of the problem that we're seeing around the country. We're seeing somehow this linkage between religious belief and people who are LGBTQ, and the courts are, in some cases, protecting what they claim to be a religious belief of the people who refuse to serve people who are LGBTQ, including people who are transgender. That, I think, is the biggest threat to LGBTQ rights that we're seeing in the courts these days. Next slide. So I did want to talk about religious freedom laws, but first I want to talk about how this is part of a backlash. Now, we're seeing lots of progress as LGBTQ people and for our community. I think that's wonderful, but it's provoked a backlash. And some people have said, oh, we're moving too fast, we're moving too hard. I think that's low crap. What's important is that we go ahead and move as far as we can, as fast as we can toward equality. And there's going to be a backlash, but there was always going to be a backlash to our progress. What's important is that we keep moving forward, that we keep advancing our rights, and that we move forward together, because these issues affect us all. All right, talking about religious freedom laws. There is a number of challenges on a number of different grounds using people's religion. The first I wanted to talk about isn't actually in the outline, but it's a guy named Byron Tanner Cross. Now, Byron Cross likes to go by Tanner, although that's not his name. He was a teacher in Loudoun County, Virginia, and he refuses to use the pronoun of choice for his transgender students. And this is what he said about it. By the way, his name is not Tanner, it's Byron. He insists on being called Tanner, but he won't honor the pronouns of his transgender students. You know, at that point, irony is dead. All right, so what Tanner said was, I am a teacher, but I serve God first. And I will not affirm that a biological boy can be a girl and vice versa, because it is against my religion. It is lying to a child, it's abuse of a child, and it's sinning against our God. And that last phrase is what makes my blood run cold, because here you have a teacher who is refusing to respect his students' gender identity. He insists on being called Tanner, although his name is Byron, and he talks about our God as if everybody shares the same God, as if everybody shares the same religious belief. And that's the problem. Everybody has their own set of beliefs, and I believe those beliefs should be respected. But that requires reciprocity. You can't be respecting the dominant religion because that excludes respect for minority religions, for every other religion, or for people who don't believe in God at all. What the First Amendment says is that the government can't make laws that infringe on somebody's free practice of religion. But it isn't practicing your religion to be baking a cake. It isn't practicing your religion to be teaching a class. Those are secular activities, not religious ones. And if a church wants to say, if you're LGBTQ, you are not welcome here, we can put that in the parking lot. If that's what they want to do, that's fine. That's practicing their religion. But when you open your doors to the public to engage in business, that is not practicing your religion. So what you've got are people hiding behind their religion, saying that we're going to disguise our prejudice as piety. It is no such thing. One other case that I wanted to talk about was a guy named Maurice Bessinger. Now, Maurice Bessinger ran a bunch of barbecue restaurants in South Carolina. And he called his restaurants Piggy Park. And the thing that I really like about Mr. Bessinger is at least he didn't lie. He put the fact that he was a discriminatory pig right up on his building because he refused to let people who were African-American into his restaurant. He segregated his restaurants and he defended lawsuits against him on the grounds of religion. He said it violated his sincerely held religious beliefs to serve people who were African-American. That didn't fly then, it shouldn't fly now when the conversation is about people who are LGBTQ. So there are a number of other instances where we've seen people refuse to serve people who are LGBTQ, and in particular, people who are transgender. I wanted to talk about Tyra Hunter. Tyra Hunter was a trans woman who was in a car accident in the District of Columbia. And she had an 86% chance of surviving her injuries when EMTs cut off her clothes and realized that she was transgender and then refused to treat her. They took her to Georgetown Hospital, where the emergency room refused to treat her because she was a transgender woman, and Tyra Hunter died. So when people say, oh, you know, it's my freedom of speech, it's my freedom of religion not to serve people who are transgender, I would point out that Tyra Hunter is the reason that they can't play that card. That's the reason you don't get to say, when I'm engaged in my business, then my religion trumps your right to service. That's not true for Tyra Hunter or for Sean Smith, who went into a diabetic shock that died because the EMTs refused to treat him. So all of that is a little scary, but things are better. Those are the arguments that we use to defeat the argument that religious freedom allows people to discriminate. It does not. All right, next slide. Certainly we're seeing challenges around the country. There are bathroom bills saying that you have to use the bathroom that corresponds to your gender at birth rather than your gender identity. And most of those bills are going down to defeat, which is great. 30 states have enacted them or are considering them, but most of those bills have failed, which is great. There are still some states where they have passed. Tennessee, for example. Ohio just passed a law saying that it's illegal to provide gender-affirming healthcare to minors. And they justified that law on the grounds of child abuse. And you sit there and you think, how many of our trans kids harm themselves or commit suicide because they don't get gender-affirming healthcare? Nobody seemed to take that into account when they passed this bill. It's so frustrating. When you want to talk about whether or not it's harmful to children, I think we have to take into account our trans kids. they get to live their lives, and they get to get the medical treatment that they deserve so that they can live authentically, so that they can live happy and healthy lives. Next slide. All right, so what can we do to help people who are LGBTQ and facing this sort of discrimination? In the first place, know the law. In California and at the federal level, because of the Bostock decision and because of the LGBTQ caucus in the California legislature, it's illegal to discriminate on the basis of gender identity and gender expression in California, and I would argue around the country. Now, there's a lot of action in the courts these days saying that in other states that discrimination on the basis of being LGBTQ or being trans is legal. I think that those laws are going to be fought for a while, but that ultimately we are going to win, and love and the right to live your life the way you choose will win out. Second, fight hard to retain the rights that you have as a trans person in California. I mean, California is at the tip of the spear on these issues, which is one of the reasons that I love living here. We are breaking new ground, protecting people who are trans in gender identity and gender expression, and I think that's awesome. Third, stand up for people who are being harassed. The things that are said about people who are LGBTQ, and especially people who are transgender, would never be said about race or other topics where there's been a history of discrimination. This is the last socially acceptable discrimination. At least people who are racist are usually too embarrassed to say it in public, but people who are discriminatory on the basis of homophobia or transphobia actually say it in public, and we need to say something when we hear that. Finally, and this is what I'd like to end my presentation on, we need to be louder than the voices of intolerance. Now, there are a lot of people out there who are really loud on these issues. They are beating their Bible and saying, this is my right to discriminate on the basis of transphobia. It is absolutely not. I think we need to be polite. I think we need to be gracious, but we need to stand up to those people. And I think we all need to remember that just because somebody is shouting it loudest doesn't mean they speak for anybody but themselves. I think ultimately, non-discrimination and love will win out. And I'm happy to be a part of that. If anybody is interested in getting a name change and gender marker change done, go ahead and contact the Center, Orange County, and we can put you in the queue for our legal clinic. And everybody enjoy Pride. Thank you.
Do you want to take questions first, or should we go to my presentation?
However we'd like to do it. If anybody has questions, we're happy to take them. Otherwise, we will turn it over to Samuel. And forgive me, but I'm losing the tie.
Yeah, and sorry for the mask, but you know, you gotta do what you gotta do. I think we're all used to that at this point too. All right, I will start sharing screen for employment rights. So this will be a little bit more uplifting, following the kind of downside. Oh, there we go. So know your rights. You do have employment rights, and you'd be surprised how many rights you have actually, especially after that depressing presentation. But
out.
Well, it was uplifting at the end, at least. You know? But like, as Stephen was talking about with Bostock versus Clayton County, the Supreme Court held that firing individuals based on sexual orientation or transgender status violates Title VII. And Title VII is a federal law that applies to employers of 15 or more employees. And that applies to every state in the US, so it doesn't even matter where you are. California also has its own state law, the California Fair Employment and Housing Act, FEHA, which extends protection to employers with at least 5 employees. So you also have protection even in small organizations in California, so you're a little bit even more protected here. And their harassment provisions actually apply to every entity, no matter how many employees there are. So if you're facing harassment at work, even if you're the only employee there, you're still protected under California state law. And federal contractors are also covered under a separate executive order. So even though often contractors aren't covered, you're still covered if you're a federal contractor. And if you experience the discrimination, you likely have claims under both state law and federal law. It's always a good idea to talk to an attorney to find out what claims you actually do have and what you can pursue. And just following the same disclaimer as what Stephen said earlier is this is not legal advice. This is just kind of some information. And if you feel like you've experienced discrimination, you should always talk to an attorney. And as Stephen was talking about too, that it might not apply to religious entities. So if you are working for a religious organization, you might not have the same protections. We can move on to the next one. All right. So the law forbids discrimination based on sexual orientation or transgender status for any aspect of employment. So that's hiring, firing, pay, job assignments. They can't demote you. They can't make it so that you can't work with certain clients. They can't make it so that you're not allowed to be public facing. You have all the same rights as everybody else in employment. And the employers cannot prohibit you from dressing or presenting consistent with your gender identity. You're protected even if you transition on the job. You're protected if you come out or choose not to come out. And California state law even protects specifically gender nonconforming and non-binary identities. So you have that built into the California law. So you're pretty well protected there. And they can't even justify their discriminatory actions based on customer or client preferences. So if they tried to take you out of a public facing role because they think that the client wouldn't be accepting of you, they cannot do that. That is not, that is completely illegal discrimination. You're also allowed to use the bathroom that you're most comfortable with. Parents and family members are also protected under California state laws. I see the question in the chat. So if you have a parent or family member or friend that's LGBTQ, they can't discriminate against you for associating with them. And kind of going a little bit further in the elaboration of bathroom rights. So the Supreme Court refused to address the issue of bathrooms during the Bostock case, but the EEOC and OSHA have already taken the position that under Title VII, employers cannot deny an employee equal access to bathrooms, locker rooms, or showers. And the EEOC has actually been enforcing this for quite a few years, I think since about like 2015 or something like that. And they are very solidly in that position. So the EEOC will help protect you there. So you have the right to use the facilities you're most comfortable with, and an employer cannot condition that right on whether you've undergone any medical procedure. They cannot require that you use only a single user restroom, but they could make a single user restroom available to all employees if all employees choose to use it, but they can't force you to be in a different restroom. And if an employer refuses to allow you to use the bathroom, it's always good to contact an attorney immediately. You could also file a charge of discrimination with the EEOC yourself, and we'll provide you with a copy of these slides so you have the links on your screen. Further protections under California law. California also prohibits interviewers from asking job applicants about their sexual orientation, gender identity, or gender expression. They can't require you to disclose your gender on an application. So if you see a gender box on your application and you don't want to fill it out, you're completely fine. They're not allowed to deny your application based on you refusing to answer that question. And you can answer it however you'd like to, so you can self-attest to that. They can't discriminate against you for, oh, sorry, can you go back one? They also can't discriminate against you for health care plans. So employee-provided health plans, as well as Medi-Cal, must include medically necessary gender-affirming care, and the health plans cannot exclude same-sex spouses. And any harassment is prohibited against employees, applicants, unpaid interns, volunteers, contractors, and it applies to all workplaces for any sort of anti-harassment measures, no matter how many people are in that organization. And I can go into the next part. So harassment and hostile work environment. The law forbids subjecting employees to any sort of workplace harassment, any sort of hostile work environment, which includes offensive or derogatory remarks about sexual orientation or transgender status, any slurs, and that even applies to intentionally and repeatedly using the wrong name and pronouns to refer to a transgender employee. So if somebody is harassing you by refusing to use the correct name and pronouns, you are protected there. Harassment is unlawful when it's frequent and severe, if it creates a hostile work environment, or if it results in an adverse employment decision, such as being fired or demoted. Anyone could be a harasser at your work, whether it's a supervisor, coworker, someone who's not an employee as well, such as a client or customer. If you have a frequent client or customer who is harassing you, your organization can be held responsible if they do not take steps to protect you from that as well. And if the behavior is so harmful that interferes with your ability to do your job, it's illegal harassment. And that includes any hostile, offensive, or intimidating work environments. You can move on to the next slide there. So what to do when you face discrimination or harassment? First of all, you should always document everything. Write it down, no matter how small you think it is. Even if there's no other witnesses to any act or a comment, document who said what, when, and where. Because even if there aren't any witnesses, you might see a pattern, and there might be other people who noticed a pattern as well who could attest to it, and that will back up your case. And if there are witnesses, document who witnessed the incident, and that will help your case as well. Save all relevant emails, texts, papers, any sort of paper trail that you have. Let's see if I see a question there. So what mechanisms are there to enforce that? That will actually be coming up. I will discuss that. So one thing is, once you face discrimination or harassment, you should contact an attorney. Attorneys will help you figure out what claims you have, where to file, how to navigate through all the twists and turns of legal procedure. And even if you can't afford an attorney, there are nonprofit legal organizations that provide free legal services to low-income residents. And the Public Law Center is very great in Orange County, and they work with LGBTQ clients all the time. So they're a good resource to reach out to. So here's where I'm kind of talking about the mechanisms. So there are some time limits that you have to keep in mind, and there are multiple different mechanisms. So you can file a charge with the EEOC for federal claims. And for the EEOC, you have 180 days to file, which might be extended to 300 days if the charge is also covered by state or local anti-discrimination laws. Federal employees have shorter deadlines where they have to contact their EEO counselor within their office within 45 days. And the EEOC is very great when it comes to LGBTQ rights in California. They are quite educated on it as well. When I was working there, they had all the employees sit through a presentation about trans rights in the workplace, and they are pretty well informed at this point. So, and even if you have somebody who's not informed, they will still fight for you, I'm sure. And you do need to file a complaint with the EEOC before you can bring a lawsuit in federal or state court, and they will give you a notice to right to sue. Then you'll have a certain time limit to file the lawsuit after they give you that notice. And it's always best to contact an attorney to help you file the complaint. You can always file it yourself, and you can always try to get an attorney later, but it's always good to have the attorney know how to get through all of the bureaucratic red tape parts of it. Then you can also file with the Department of Fair Employment and Housing for California state law claims. That's the state agency. You have 3 years for that. And you have to file with the Department of Fair Employment and Housing before you can file in court. Usually if you file with the EEOC, it will also be automatically filed with the Department of Fair Employment and Housing. And I know this is all very confusing, because there's so many different like little twists and turns of different agencies to go to and different steps before you can even get to the court process. But the Department of Fair Employment and Housing and the EEOC are kind of like almost miniature courts that will kind of go through your case. And then from there, you can also go to the actual court. And I know that that's still very confusing. So the best thing to do is always to talk to a lawyer, because they will know all these procedural things that are pretty, you know, they're difficult to navigate on your own. If you're not like professionally a bureaucratic red tape navigator, they can be kind of difficult. But just knowing the timelines of having that like 180-day deadline is a good thing to have in your mind, that you should reach out to an attorney sooner rather than later. And even if you file with the EEOC or the Department of Fair Employment and Housing, employers cannot retaliate against you for that. So you should never be afraid of having something negative happen to you at your job for you filing, because as soon as they retaliate, you have another claim. So when you should contact an attorney, you should contact as soon as you feel like you face discrimination. Even though you won't have the 180 days to file, you should give yourself and your attorney as much time as possible to gather and organize evidence. Your attorney will probably give you some ideas of some other documents that you could gather. You might be reaching out to other witnesses and whatnot. So giving yourself as much time is always beneficial, especially when they have to navigate through all of the red tape process as well, which can take some time. And then you can always update your attorney with any new changes as they occur. If you've been fired, demoted, or faced any adverse action based on a discriminatory reason, then you should contact the attorney immediately. Especially being fired, demoted, or facing an adverse action could pretty much change how fast your case goes. So you'll definitely want to contact the attorney immediately about that information. And then, like I said, we'll provide you with a copy of these slides so that you can have these resources. But just remember, the EEOC is out there to help out. The ACLU also gives you information about LGBTQ employment rights. The Department of Fair Employment and Housing will give you instructions on how to file a complaint. And then you could always reach out to the Public Law Center for an attorney if you cannot afford an attorney yourself. They will help you out with providing legal aid. Is there any other questions?
If there are questions, we'll go ahead and take them. There are a couple of things I wanted to jump in on. Questions? Okay, first, I litigate a lot of LGBT and especially transgender discrimination cases on behalf of plaintiffs, the people who are actually bringing the suit. So a couple of things in the practical, like Samuel mentioned, it's important to build your case, write everything down, print out the emails or something that is offensive or troubling, because your employer actually owns your email system if it's a work-related email system. So as soon as you're gone, they can go ahead and shut down your access and you don't have access to that evidence anymore. So print out the emails if there are bad emails in your work email. You have to give your employer a chance to remedy the situation. So what's really important is that you go ahead and document in writing when you let your employer know that there was a problem. I'm still representing a transgender woman who was working on a food processing assembly line. And she wore green eyeshadow to work. And her employer said, you have to wash that off or you're going to be fired. And she said, why? And they said, well, because it makes you look ugly. That's what happened the day that she was told to wash her face off. Well, other women never had to do that. Other women never had to wash off the makeup. And so when I confronted opposing counsel about that, his argument was, well, the eyeshadow could have fallen off into the food. And I was like, well, she's not a Kardashian. She's not wearing that much makeup. You know, come on, be serious. But the whole point is what she did to build her case is she started complaining and keeping copies of her complaints that she submitted to her employer over a 15-month period. That makes the case a lot easier to prove. You know, there was a question in the chat about how do you prove that discrimination was actually the motivator behind some of the discriminatory behavior that's taking place in the workplace. Because the employer responds by saying, oh, well, it was a performance problem. That's why this person was demoted or fired. Well, you always face that. There is no such thing as a perfect case. And so that's the way you have to defend these lawsuits. If you're coming from the employer side, you have to say there was a legitimate business reason for us doing what we did if it's a wrongful termination case, for example. A lot of times, people have really good performance evaluations. Save those because they show that whoever the plaintiff was, they were doing their job well. It wasn't a performance issue. And timing is really important. If you get a comment and then you respond and say, hey, that is not right, and then the next day you're fired, that timing makes it very suspicious that what's really motivating the employer is actually discrimination rather than any sort of performance issue, particularly when you've worked somewhere for a long time or you've got good performance evaluations.
Just to build off that, the EEOC and the courts do look very carefully to see if the excuses are in fact just excuses, if they're pretext for actual discrimination. So documenting everything is very important because that could show indications that you're not really being fired for the reason that they say that you're being fired.
And, you know, no employer is ever going to say, yeah, you got me. Yeah, we were discriminatory. So it's always going to be about performance. That's always going to be the way they defend these cases. That's okay. You know, I've been practicing for 33 years and I've never had a perfect case. There's always going to be some performance issue if you work somewhere for a long time. I represented one woman who worked for a hotel in Anaheim for 10 years and had great performance reviews. And then once she transitioned, her employer said, okay, you have to write a letter, put it up at the front desk and at the housekeeping station, letting everybody know what you're doing. And you can't do that. They also forbid her from wearing nail polish, from growing her hair long, from wearing clothes that fit her gender identity. None of that is legal. So the fact that you've got kind of this set of circumstances, like being prohibited from wearing clothes that conform to gender identity, like the letters, all of that went to help prove the case. And of course, the employer defended on performance grounds, but she'd worked there for 10 years and she had great performance reviews. So that really didn't hold up. Other questions? Any other issues you'd like to talk about? One thing I would like to mention, there's a job sharing relationship between the EEOC and the DFEH. And so if you go ahead and file with one, you don't have to file with the other. The EEOC has much shorter timelines, but you can file with the Department of Fair Employment and Housing in California for a much longer period. So even if you miss one deadline, it doesn't mean that you've lost your case and that you're never going to be able to file. Even if you miss the deadline with the DFEH, sometimes you can extend that for about 90 days. If, for example, your employer knows that you are going to be raising a claim, but you miss it by a few days, you might be able to salvage it. But it's really important, particularly if you get fired, that you act quickly to go ahead and get with an attorney and raise your complaint promptly, or you might lose it out because it gets time barred.
And remember that your HR office isn't really there to protect you, it's there to protect your employer. So even though you file things with the HR and file complaints with them, document it yourself as well.
Get a copy of whatever it is you give to HR. I think that's a great point, Tim. All right, any other questions?
For Stephen and Sam, I was wondering if we have folks in the audience who are looking to get started on either potentially changing their gender marker or their name, how would you suggest their next steps would be after transpired here?
So we run the legal clinic, and Samuel is one of our student leaders. We run the legal clinic 10 months out of the year, and you contact the transgender services coordinator, and I know that that position isn't filled right now, but you can contact the OC Center. And we also have an email for what we call TLAC, Transgender Legal Assistance Clinic. Samuel, do you have that email handy?
Yeah, I could throw that in the chat.
That'd be great. So go ahead and schedule an appointment. I love doing that legal clinic, and 70% of people who are transgender never get their name change and gender marker change done. And there are two reasons for that. One is it's daunting. I mean, lawyers don't talk like normal people, because if we did, we couldn't charge what we charge. So it's daunting to try and go into the legal system and try and navigate it without a guide. Well, we give you that guidance. The other reason is cost. We can help you fill out what's called a fee waiver. And so if you qualify for a fee waiver, there's no charge for getting your name change and gender marker change done. We help you with all the documentation. We schedule these one night a month, 10 months out of the year. And we are delighted to help. I didn't understand just how important a name change and gender marker change was until I talked to a woman who'd never left California, because the last time she did, she went to the Grand Canyon and tried to use the ladies' room. And a man stood in front of her and said, "You can't do that. My wife and my kids are in there," and called the police. And so she came to California and got her name change and gender marker change done. Then her driver's license matched up with her gender expression, and she was able to travel again, which was awesome. So we are happy to help. We'd love to see you all if that's something that you need. So go ahead and get in touch with us.
I guess one more question, just in case we have anyone in the audience who might be trying to kind of get their name change or information maybe about a gender marker change and are concerned about their guardians or parents or folks being aware that they might be trying to get this information. Does that happen in the legal clinic? And if so, what do you usually tell those folks who show up looking for discretion?
Samuel, you want to field that one?
Sure. So we will be discreet with giving you information, but there is one thing to know is if you get your name legally changed as a minor, you need parental consent. So that is an issue and a hurdle, of course. But of course, if you're seeking out information, just so that you know what to do when you turn 18, we've had a few people who were 17, and we're just kind of looking forward to the process towards once they get their birthday happening and they wouldn't have to worry about parental consent anymore. And of course, if you got your name legally changed, your parents would find out, obviously. So it's pretty difficult for minors to keep it a secret completely from their parents. But if you seek out information from us, we're not going to tell your parents. We're not going to contact any sort of guardians or anything.
Exactly. Everything that we do is confidential, between, if it's a minor, the minor's guardian or parent. The other issue is that the law has been changed so that you no longer have to publish notice of your name change and gender marker change if you're doing it to conform to gender identity. If you're just changing your name, you go ahead and have to publish that in a newspaper of what's called general circulation. We usually pick a newspaper in Westminster. It's a Korean language newspaper because most of the people that we see are not Korean. And so, you know, you publish, it qualifies, you show that to the judge, and you can go ahead and get your name change and your name change done. If you're changing your name and your gender marker to conform to gender identity, you no longer have to publish at all. You also don't need a doctor's note or letter saying that that's what's happening. It's self-attestation, so you can keep those issues private. You don't have to publish, and you don't have to tell your doctor.
It's also really easy to change your gender marker on your driver's license. You just tell them what gender marker you want at the DMV, and that's all you have to do for changing your gender marker. But for changing your name, you need to get the court orders. So if you wanted to do those 2 steps at different times, you're allowed to do that.
Okay, I see a question from Kim about trying to start, let's see, LGBTQ positive club on campus in my elementary school. There are several laws that address LGBTQ issues in schools, including elementary schools. Most of them are general, and so they don't apply just to elementary schools. Administrators a lot of times do show resistance to those sorts of things because they feel it's a little too early to be discussing things like sexuality. And I couldn't disagree more. I mean, kids are starting to have sex or starting to address these issues even internally at a much younger age. We want these issues addressed in a healthy way. But there are a number of laws in the state of California that actually go ahead and protect your right to do those sorts of things, like start an LGBTQ positive club at schools. You're going to get some resistance from administrators, but you can push back with those laws. I don't have the citations here, but I'll go ahead and make sure that Nikki gets them, and perhaps she can she can send those off to me. Happy to. All right, anything else? All right, well, thank you very much for having me. I really appreciate the opportunity to talk to you, and happy Pride.
Yeah, happy Pride, everyone.